Nancy Stroud and Janet Bowman. I'm going to give a brief bio for each of them. Nancy Stroud practices land use law with a focus on representation of local governments. She graduated from the University of North Carolina with a JD and a master's degree in city and regional planning. Nancy is a fellow of the AICP. She is active in the National APA, having served for many years on the APA Amicus Committee, and active in the Florida chapter. She has written several amicus briefs on behalf of the national and Florida chapters. Among her other clients, she is currently the land use attorney for the newly incorporated village of Estero in Lee County. Janet is a senior policy advisor for the Florida chapter of the Nature Conservancy, where she focuses on state governmental affairs, Gulf of Mexico restoration, and climate policy. She has also served as legal director of 1,000 Friends of Florida, attorney for the Senate Committee Affairs Committee and the Legislative Committee on Intergovernmental Relations, and senior attorney for the Department of Environmental Protection. She is the past chair of the Environmental and Land Use Law section of the Florida Bar, and a frequent speaker on conservation policy topics. In 2018, she served as an adjunct professor at FSU College of Law, teaching environmental law. She received her JD from FSU College of Law and her BA from New College of Florida. Nancy will go first, Janet will go second, and I'll do cleanup. We're going to try to leave some time for questions if you all have any, and welcome to our presentation. Thank you.
David, introduce yourself.
Oh, I'm David Theriak.
No.
I am David Theriak. I'm an attorney out of Tallahassee. I have a statewide land practice, land use law, represent all three sides. Presently representing, I think, 7 or 8 local governments right now. Also represent private developers trying to develop their property, and I represent neighborhood associations that are suing private developers. So we kind of do all three sides of the coin. I see many familiar faces, so it's good that you're here, and I'm hoping we give you a nice session today. So thank you.
Good morning, everybody. Thank you for attending this. David and I have been doing this for several years now, and it's always a lot of fun. We like to leave time for questions, so we're hoping that we're able to do that because we've got a lot to cover today. And what I'm going to cover are 2 topics. Most of the time will be about the consistency challenge of Imhoff et al. Versus Walton County that is currently in the First District Court of Appeal. And then there's a recent Burt Harris case that I'd like to cover briefly. But I'm really very concerned about the Imhoff case because this, like another case that APA entered an amicus for, is an argument by APA that when a consistency challenge is brought, consistency is not limited to use, density, and intensity issues, but that the legislation, the Community Planning Act, one of its most basic foundational issues is that all development needs to be consistent with the comprehensive plan, and that means everything in the comprehensive plan, not just use, intensity, and density. And there seems to be a movement to argue that it's only use, density, and intensity that matter. And there's one district court of appeal in Florida, the Second District Court of Appeal, that has accepted that argument. So now we're seeing these cases pop up in the other districts. And the most recent one is the Imhoff case. This is a case in which Walton County approved a PUD called the Cypress Lakes PUD. And that PUD is one which involves 141 residential units of a mix of types and some commercial, 53,000 square feet of commercial uses in 4 different buildings, all mixed uses. The parcel that it was on, or is on, is designated for neighborhood infill in the comprehensive plan. It involves 24 acres along Route 30, which is a county-designated scenic corridor. And I think most importantly, it's adjacent to Topsail Hill Preserve State Park on two sides. And when the county approved this PUD, neighbors and certain nonprofit groups brought a comprehensive consistency challenge under Section 163-3215 of the Community Planning Act. Now, the claim by the challengers is that involved 5 different inconsistency claims. One, that the density and intensity of development was in excess of that allowed by the comprehensive plan. And it really involved the methodology of how you calculated density in a mixed-use development. And then there were others, including violation of the setback requirements for construction within the scenic corridor, violation of buffer requirements, and violation of the requirement that streets in the area have sidewalks along both sides. All of those requirements were in the comprehensive plan, and the challenge was that the PUD did not respect that. So it went to court, and the trial court held that statutory inconsistency challenge is limited to enforcing only the comprehensive plan policies that govern use, density, or intensity. So only one of the challenges could go forward, that first one about the density. And it cited to the Second District Court of Appeal case, the Heine case that we talked about, I think, 2 years ago when it came out. And it says, quoting Heine, that this section, the consistency challenge section, authorizes aggrieved or adversely affected parties to seek de novo action for declaratory, injunctive, or other relief against any local government to challenge any decision of such local government granting an application for development order, and this is the key word, phrase, which materially alters the use or density or intensity of use on a particular piece of property, which is not consistent with the comprehensive plan adopted under this part. So in that way, the court said, we can really only look at consistency challenges to use, density, and intensity of use. So APA, Florida, and National APA got involved to file an amicus brief in the First District Court to argue that consistency challenges under the statute and settled case law are not limited in the way that the trial court and the Heine case said they were limited. And if you recall, the APA and APA Florida entered an amicus brief in a trial court proceeding in Miami last year to beat back this same claim. And the Third District Court of Appeal, I'm sorry, it wasn't in the trial court, it was in the appellate court. And the Third District Court of Appeal approved the trial court decision, which used this limited interpretation, with a PCA affirmed, which in legal jargon means that it affirmed the case, but it didn't set any precedent. So the only precedent we really have at this point is out of the second DCA. But the question is the first DCA going to, join the second DCA in that interpretation? And it's important to point out that APA was not taking a position on whether or not the development was a good development, or even whether or not it was consistent with the comprehensive plan or inconsistent. The position is about how do you apply the statute in a consistency case. Should you apply it in this very limited fashion, or should you apply it the way the courts have applied it until the Heine case, and what we think the statute says, to every element of the comprehensive plan, all goals, objectives, and policies. Now, planners, I think, in Florida have just accepted that that's what comprehensive planning is about. That's why you have multiple elements. That's why you have goals, objectives, and policies. That's why consistency is so important, because you want to ensure that development orders don't just worry about the use, density, and intensities in the plan, but everything in the plan, which is supposed to be the constitution for land use. So let's look at some of the relevant sections of the community planning act, because this is what the court has done. This is what the argument was. The court, in fact, I think, only focused on that one section that I read earlier and did not consider the rest of the sections in the comprehensive plan that really should be looked at together to really understand the intent of the legislature. And one provision in the plan is in 3161, which specifically states that no public or private development should be permitted except in conformity with comprehensive plans or elements or portions thereof prepared and adopted in conformity with this act. It doesn't say should be consistent with use, density, and intensity. It says with elements or portions and with comprehensive plans. And again, in subsection 3194(1)A, the statute says, after a comprehensive plan or element or portion thereof has been adopted in conformity with this act, all development undertaken by, and all actions taken in regard to development orders by government agencies in regard to land covered by such plan or element shall be consistent with such plan or element as adopted. And again, in 3194(3)A, development order or land development regulation shall be consistent with the comprehensive plan. Well, this is the definition of consistency. If the land uses, densities, or intensities, or other aspects of development permitted by such order or regulation are compatible with and further the objectives, policies, land uses, densities, or intensities in the comprehensive plan, and meet all other criteria enumerated by the local government. Again, not just limited to those three kinds of aspects of the plan. So again, this is the statutory language that creates a consistency challenge in which the court in Heine and in Walton County now are interpreting, the courts are interpreting. Any aggrieved or adversely affected party may maintain a de novo action for a declaratory, injunctive, or other relief against any local government, challenge any decision of such local government, or to prevent the local government from taking action on a development order as defined in section 163-3164, which materially alters the use or density or intensity of use on a particular piece of property, which is not consistent with the comprehensive plan. So what the court in Heine and the trial court in this case has said, the consistency part is whether or not the development order is consistent with the use or density or intensity of use. And that's not how we think it should be read or how the courts have read it before. What really this section is doing is creating the cause of action, and it says, what kind of development order can you bring to a consistency challenge? It's only an order that changes or materially alters the use or density or intensity of use on a particular piece of property. And there's case law that says this. If, in an earlier Walton County case, if the PUD approval did not materially alter any of those things, it was not challengeable under the statute. If it does, you can bring a challenge, and then what does the challenge involve? It involves consistency with the entire plan. And that means all the goals, objectives, and policies, because consistency is defined to include all of those things. And then not only do you look at these other sections of the Act to understand what the intent of the original Growth Management Act was and how it's carried over into the Community Planning Act, but it's clear that the legislative intent of the original legislation continued into current legislation is to create citizen standing to enforce the consistency mandate. That's the only way that consistency is enforced, by allowing affected parties to bring these de novo actions to the trial court. There's no other way to do it. So from our perspective, in order to enforce the consistency mandate, the act really needs to be understood to include consistency with all parts of the plan. So we know this from a whole series of cases, and of course the most important case for us is the Snyder case, in which the court established a strict scrutiny standard for the comprehensive plan. It is so important to have consistency that the court said, we're going to look beyond what the local government might say and whether it's fairly debatable or not. We're going to look very closely at it. We're going to use strict scrutiny. And strict scrutiny is a term that was adopted from an earlier case from the Third District Court of Appeal that says that strict scrutiny looks at whether a proposed development conforms to each element and the objectives of the land use plan. And in Musgrove, because appellants were unable to show that their commercial property was consistent with each element of the land use plan and further its objectives. In this case, the court was calling the comprehensive plan the land use plan. It's an old Miami-Dade County reference. So the other thing the statute says is that the act is to be construed broadly to accomplish its stated purposes and objectives. That's the legislative intent, and it's what's considered a remedial statute. And appellate courts from all the districts have applied the act as intended, except this recent Jaime case, including the First District Court of Appeal, where this current case is now, which says, in one of the cases, there are several of these, but one, citing to the Machado case, that Musgrove case that I mentioned before, we apply strict scrutiny, a process which involves a detailed examination of the development order for exact compliance with or adherence to the comprehensive plan. And it's well established that a development order shall be consistent with the governmental body's objectives, policies, land uses, etc. So we'll see. We'll see if the court accepts that. I think as planners, it would be shocking if they didn't, but we do have this Jaime case out there, so it's possible that they will. What are the takeaways from these cases? I think it's very clear to all of us that although planners, local governments, others involved in the development process really understand comprehensive planning in Florida to be different, that it's foundational, that consistency is an important part of the comprehensive planning process. Judges don't necessarily know anything about that. And so one of the reasons that APA entered as an amicus was to educate the board, hopefully, to that. It's incredibly important, I've said it a number of times, that it's the consistency mandate is the way that the comprehensive plan is effectively carried out. We do know that the Florida system of judicial challenges to land use decisions is complicated. It's complicated for consistency because there's only one way to challenge it. The importance of it can't be overstressed. The problem is exacerbated, I think, by the 2018 amendments from the Florida legislature that Janet's going to talk about, that provides inconsistency challenges that prevailing parties are entitled to attorney's fees and costs, including appellate fees and costs, which is a very unusual provision to have in any kind of civil challenge. This was a provision that is going to, I think, chill the citizen enforcement of the consistency mandate, or even enforcement by developers and other affected parties that can enforce it. Because the risk of having to pay the other attorney, the other party's fees can be substantial. In de novo actions, that means it's a whole trial, and trials are expensive. And experts can be very expensive. So I think for most citizen groups, at least, they're going to say, how can we afford to do this? We just can't. Okay, that said, the good news is that from my perspective, is that there's a very recent Burt Harris case from the Florida District Court of Appeals that came out in June, which helps us to remember what Burt Harris claims are all about. In this case, the city had enacted its historic preservation ordinance back in 1984, along with, its LDR adoption. And for years, like most jurisdictions that have historic preservation ordinances, have been designating properties and looking at certificates of appropriateness and what can be done in those properties. In 2012, a single-family residence subject to this case was designated as a historic structure because it had been designed by a famous architect and owned by a famous philanthropist. The original owner died, a new owner acquired it and wanted to tear it down, and the city denied a demolition permit for this property. And the court explained that the Harris Act expressly states that its provisions do not apply to the application of any law enacted on or before May 11, 1995. This is a grandfather provision. And I've said it out there, I don't have to read it. So the question in this case is whether the grandfather provision bars the Burt Harris claims when the ordinance at issue was enacted prior to that date, that grandfather date. But the application of the ordinance and a denial of the demolition permit occurred later. And the holding is that there is not Burt Harris claim. This is an old, pre-existing land development regulation, even though it was applied after the grandfather date. The grandfathering means that there's no Harris Act claim. So I think we forget that sometimes. What does this mean for planners and local governments? This is good if you have a very good system of land development regulations enacted before the grandfather date. But what happens to the enactments after that? I'm a land use attorney that is now representing a new village. They're just about to adopt their land development regulations. This is kind of giving me pause. Does that mean that every land development regulation, including the historic preservation ordinance, that now is incorporated in the new LDRs, is going to be subject to Harris claims? Any action taken, based on those new LDRs are going to be subject to Burt Harris? Maybe so. So does that chill the ability of local governments to update and enact new land development regulations? Do you have to think twice before you do that? And on the other hand, is the Act simply a recognition that the principle that owners should be aware of existing regulations and not have a reasonable expectation that any substantial financial burden will lead to financial compensation? If you come into a jurisdiction and there's an existing system of land development regulations that's been there for 35 years, Should you have an expectation that somehow it's unfair under the Burt Harris Act that the jurisdiction would apply those those LDRs? I think the legislation is just a recognition that that's not necessarily unfair, and it really shouldn't be a basis for a claim. So that's what I have, and I'll turn it over to Janet.
For those of you standing in the back, there's a chair here, and we can bring one over here if you want to sit down. People are pointing as well. Otherwise, you're free to keep standing. Enjoy.
Good morning. How are y'all? To get a little idea of who's in the audience, how many of you all are lawyers? Okay. And how many of you are local planners? And how many of you are developers? Okay. And how many are you citizens, nonprofit, other? Yeah? Okay, great. All right, so we've got it all, right? So I'm going to follow up a little bit on Nancy's discussion of consistency. And this is really a hot topic right now that has emerged from enactment during the 2019 legislative session of House Bill 7103. How many of y'all are familiar just generally with some of the requirements of 7103? I mean, it's one of the most significant, in my mind, growth management pieces of legislation to pass. I agree with that. Really, I think since 2011, and if you haven't really kind of gone into it, you should spend some time with it. I'm not going to talk about all of the permitting and some of the other provisions. I'm specifically going to talk about some pieces that I think really have significance in terms of land use practice, and also in terms of I'll call it the integrity of the comprehensive planning process. Okay, so Nancy talked about this a little bit, but generally, looking at 162.32.15, I mean, there are two different routes for challenging consistency in development orders, and 163.32.15.3 is really the most common, which is a de novo proceeding, where you're having a trial before the trial court, determining whether the government action in issuing the development order is consistent with the comprehensive plan. Okay, and then there's another process that is potentially out there, and that depends on whether the local government has adopted quasi-judicial proceedings that includes, certain requirements. And the local government can decide which types of development orders proceed under subsection 4. So this is something that varies from local government to local government. Okay, I'm really going to focus on challenges under 163.32.15.3, which again is a de novo action based on local government's action on a development order, which, as Nancy mentioned, material alters the use or density or intensity of a particular piece of property which is not consistent with the comprehensive plan. The de novo action must be filed no later than 30 days following the rendition of a development order. Okay, so during the legislative session, Chapter 2019-165 was enacted, and I'm going to go in a little bit into the weeds about when it was signed by the governor, because that's relevant to what I'm going to talk about a little bit. It was signed on June 28th, 2019, which is very late. Most bills become effective July 1st. I'd say 3/4 of the bills that are passed typically are effective July 1st. The other frequent effective date is upon becoming law. So again, this will be relevant when I get to it. So Section 7 of the bill that amends 163 and 3215 includes really two significant changes that are important. One, it creates a summary procedure option that either party can ask for under Section 51.011, which is in kind of the civil judicial section of the statute. And this, I think, by the sponsors was an attempt to, provide an option for speeding up resolution of these cases. However, if you look at the timeframes, requires the defendant's answers has to be filed within 5 days of service of process. Plaintiffs has to include all defenses or law of fact in his or her answer to the counterclaim and serve it within 5 days after service of the counterclaim. I mean, the deadlines are impossible and probably aren't really attractive to either side, frankly. So I'm not sure how often this will be used, but certainly if you're working for a local government that's responding to one of these lawsuits and the petitioner is attempting to invoke this. It's something that you're going to hear about immediately. And one more provision, which I didn't throw up on a PowerPoint, but I wanted to make you aware of, is there was language that was deleted regarding the intervention of the Department of Legal Affairs to represent the interests of the state in a consistency challenge. Now, I'm not aware, I can't remember this ever being invoked, but a circumstance where perhaps it could be invoked would be the effect of a development on an important state resource like a park, or just as an example. Or an important asset of the state. So that was deleted. Okay, so to the nutshell of it all, the prevailing party provision that was added states that the prevailing party in a challenge to a development order filed under subsection 3, it doesn't talk about subsection 4, only actions brought under subsection 3, are entitled to recover reasonable attorney's fees and costs incurred in challenging or defending the order, including reasonable appellate attorney's fees and costs. So attorney's fees and costs basically for the entire life of the proceeding. And, and this particular provision was effective upon becoming law. So you have the circumstance of citizen groups, others that have filed these actions that are out there, many of which are midstream, some of which have been scheduled for trial, some of which are, being at the appellate level now, that are potentially subject to having to pay prevailing party attorney's fees. So lawyers who represent third parties, in particular citizens challenging local government development orders this summer, have been faced with the decision of, advising their clients of this new provision. And clients, challengers, having to make a decision whether to proceed with these actions or not. And because of the effective date of the law, upon becoming law, they had to watch this. And if they were going to take action to dismiss, do it, basically concurrently with the the act becoming law or face jeopardy under this particular provision. So, this just became law at the end of June, and I wondered, well, what impact has this had? I mean, clearly, theoretically, it would seem to have a chilling effect on bringing actions to begin with on the part of citizens. But, what are people that are midstream? How's this playing out? So I crowdsourced my land use lawyer friends, to see what impact it's had. And typically when there are these changes in law, you sort of have to wait for them to make their way through the courts. But I will have to say with this, the impact has been immediate. So I'm going to provide you with 3 examples of cases that have been voluntarily dismissed following the enactment of 7103. The first is a pair of cases arising from Pasco County. Is anyone here from Pasco County? No? Yeah? Okay. So there were these pair of challenges to land development orders issued by Pasco County approving lime rock mining in Pasco County. And there were some neighbors that were not thrilled with the idea of, noisy mining going on next to their subdivision. In addition to the mining activity, there was also a processing function associated with it. So the first case was initiated in 2013. The original development order was issued and challenged. So, this has been going on for quite a while. And at one point, the lawyers for Outlaw Ridge filed a motion for summary judgment to overturn the challenge in circuit court, and got a favorable opinion that went up on appeal to the second DCA. And the second DCA held that, overturned the trial court, holding that there were issues of material fact that had not been addressed by the trial court on consistency. And in this case, the issue is whether this processing facility was consistent with the agricultural land use designation that arguably the mining was authorized under. So, that happened in 2015, and this particular case was ready to go to trial in this fall. They had a trial date. The second case has to do with, it's more recent, another mine, Seven Diamonds mine, similar issue. So, as soon as the legislation passed, the petitioners decided to voluntarily dismiss their action. And I wanted to read you a quote from Robert Howell, who brought one of the petitioners in the first lawsuit. To say that I'm vehemently upset would be an understatement. The law basically kills anybody's right to protect a seeming contradiction in the comprehensive plan. No average citizen can afford a lawsuit under this bill. So even though this has been voluntarily dismissed, the attorneys for one of the mines is arguing that they are entitled to attorney's fees, even though the case was voluntarily dismissed. So that it will be important to see how that lands. Okay, the second case was brought by Suncoast Waterkeeper, and it was a challenge to a development order issued by the city of Bradenton in the area of Harbor Sound. And the particular development order had to do with a 4-unit residential development that, as you see, there's a mangrove fringe around Perico Sound. And they were concerned that the development order was inconsistent with policies in the comprehensive plan protecting mangroves and wetlands. So this particular case was brought in 2015. And it was also voluntarily dismissed based on the new legislation. Okay, the final action that I'm going to bring up, anybody from Fort Myers Beach? Okay, so this has to do with a development order, actually a PUD approved by Fort Myers Beach to approve a margarita resort planned for Fort Myers Beach. And, you know, as you can see, it's a large development. It has a hotel, it has a water park, it has restaurants, it has it all. It has great names for all of its bars, you know, based on Jimmy Buffett songs, you know. Who wouldn't want this, right? Well, you know, one of the neighbors. So there were 2 lawsuits that were filed last fall challenging the development order. One was a 3215 consistency challenge, and the other was a cert action. Challenging the development order. So after the effective date of the legislation, the 3215 consistency action was voluntarily dismissed. The cert action is still out there, but the 3215 was dismissed. So, you know, during the short couple months, you know, since it's become law, you know, I mean, here are 3 examples of 3 sort of different types of consistency challenges that have all been voluntarily dismissed. And, you know, if you're a local government, you might say, well, hey, this is great, you know, you don't have to deal with the litigation. But the downside of this, of course, is that 3215 is really the only way of enforcing the consistency mandate. And, you know, if it's no longer viable to, under any circumstances, to challenge consistency determinations, it has to have an effect on, you know, how rigidly and how thoughtfully, perhaps, how consistency is thought about in terms of making development order decisions. Hopefully not, but you know, that does raise a concern. Okay, so just running through some of the considerations. We've talked about the chilling effect on citizen participation, and I would say I think it's going to have a chilling effect not just on the back end when there are challenges, but I think it could also have a chilling effect on just interest in participating in the first place. So I'm concerned about that. It certainly erodes the importance of the consistency mandate. You know, arguably there's no meaningful enforcement, and you know, it's having a negative impact on land use law practice in general. I mean, it's, you know, certainly some of my land use lawyer friends are finding their clients are not willing to bring actions even though they have legitimate consistency concerns. So that's certainly a negative impact. So we've mentioned a little bit that cert review under 3215-4 or cert review, common law cert review is an option if there are other grounds for challenging the comp plan. But this requires getting in early. It requires building a record. It's basically an appellate review of the local government quasi-judicial proceeding. So there needs to be a rigorous local government quasi-judicial proceeding, which, you know, a lot of larger local governments have, but some smaller local governments don't. And it requires building a record. And many times, you know, citizens don't have the money, they don't have the resources to get in and do that early. So just this week, several legislators, Senator Lori Berman, and Representative Casella both from the West Palm Beach area, have filed legislation that would repeal the prevailing party attorney's fees provision. So that was filed a couple days, 2 days ago. And then finally, I just wanted to sort of tee this up for discussion, and that's a lesser discussed change that's in the legislation applies to new municipalities adopting comp plan, or adopting their initial comp plan, and requiring that development orders that are out there, that the density and intensity associated with those development orders are vested in the new municipal comp plan. You know, whether or not there's been reliance, you know, they could be old development orders that have been sitting there unused for, 10 years. And again, I think this makes it more difficult for local governments to have meaningful consistency requirements. So, how are you going to apply, just say you're lowering density, you're moving density because of sea level rise on the coast, and you have this, these vested development orders that may no longer really make sense with your new comp plan, but they're now vested. So I think that has implications for the consistency doctrine, and we'll see how this plays out.
Thank you, Janet.
And now for a technologically impaired moment.
Okay. Yeah, now I can really depressed.
Keep going.
Oh, okay.
Yeah, well, it is the middle one. Thank you, sir.
Well, those were great presentations. It's always difficult to follow Nancy. This is Janet's first inclusion in the Three Musketeers in this program. So welcome, Janet. I thought they raised excellent points. One of the fun parts of being the last one to go, I'm going to address a new U.S. Supreme Court case, but before I do that, there are just a couple follow-up points that I wanted to highlight. The new interpretation regarding 163.3215, limiting it to intent and density. If you take a look at comp plan cases over the last 24 years, some of the most significant victories dealt with the environmental protections in the comprehensive plan or the compatibility provisions in the comprehensive plan, including the first temporary injunction under the Growth Management Act back in 1995, when Judge Padovano was still a circuit court judge. Florida Wildlife Federation brought a challenge to a gas station rezoning across from McCall Springs. And we were able to prove up that there was a hydrological connection between the gas station and the springs. And Judge Padovano entered a temporary injunction based upon the environmental and compatibility concerns. Well, if this new narrow interpretation is the new way to read 163, we would have lost that case. The other issue I wanted to just briefly point to is, while I agree with Janet, there's definitely a chilling effect on the prevailing parties. As y'all may recall, developers, when they're denied, are also allowed to bring a lawsuit under 163.3215. And there, with this new language, there's a potential that if the developer wins, they get attorney's fees from the local government. So there may be a chilling effect on local governments to rely upon comp plan provisions to deny. And then lastly, before I get into the Supreme Court case, if there's one bill that you need to read that you haven't read on your summer reading list, it's House Bill 7103, and we've been talking about it all afternoon or morning. But there are a lot of other nuggets. I call this the developer property owner Christmas wish list. And in here, there are time frames now that you, as a local government, must issue completeness letters. You must either deny, approve, or approve with conditions with certain time frames. Fortunately, the statute did not include what happens if you fail to meet those timeframes. So there's no sanction in the statute. I could envision perhaps a certain cause of action that you fail to comply with the statutory timeframe, but you still have the separation of powers issue that a local government cannot be ordered by a local judge to approve a project, at least now. Who knows what happens in the future. You also have language in here about inclusionary housing, that you still have the authority to require inclusionary housing, but if you do so, you have to provide incentives to cover the full cost of what it costs the developer. And we've also changed the time of impact fee collection to building permit. So if you have nothing else to do, maybe Sunday morning, and you got a cup of coffee, read through here. There's all kinds of ugly nuggets in there. So let me get to my presentation. Nick versus Township of Scott. It's a U.S. Supreme Court decision, 5-4. It arises out of a very simple set of facts. It was whether an individual who had about 90 acres of property and a family graveyard on the property, and the township passed a law that anybody who has a graveyard must open the graveyard up to the public during the daylight hours. And this property owner was cited for not opening her property up to the public, to her family graveyard. Went directly, actually started in state court. State court said there's a doctrine called the Williamson Doctrine that we get in the weeds a little bit on, and threw this Nick out of the state court. And then she filed in federal court, bringing a federal takings cause of action. Now, what's unique about this is Williamson, I believe it was decided in 84, 85. So we're looking at about 34 years of land use law with this particular case. And what Williamson stood for was that there were two prongs to be right in order to go to federal court. The first prong is the property owner had to have a final decision. The local government must have said, this is what you can do with your property. If there was still a variance or another type of cause or another type of development plan that you could get approved, you had to have a final decision so the court can measure the diminution of value between what you saw and what you got. The second prong was that the property owner first had to go to state court to obtain compensation from the state. And the reason for that, at least up until this summer, is the Fifth Amendment takings clause. It says, nor shall private property be taken for public use without just compensation. The Fifth Amendment doesn't state that property can't be taken. It just states that a local government or a county or a state can take property, but they have to provide just compensation. Williamson construed many years of Supreme Court law to state that the just compensation could be after the local government act and the property owner goes into state court and seeks a determination of whether it's a taking, and if so, they get just compensation. And what has changed is the 5-4 decision in Nick is now allowing a property owner to skip the state court compensation prong. The finality prong is still in place, but now a property owner who contends that they have suffered a taking do not have to go to state court. They do not have to determine whether they're going to be compensated by the state afterwards, and they don't even have to pass go. They just go straight to federal court. The tension in this decision, and I mentioned the bill, this is also a good case to read. You really can tell the 5-4 split in the court regarding this type of case. And I want to hit just a couple of the quotes in the decision. They're pretty telling. First, what I found pretty interesting, this Supreme Court held that the Williamson Supreme Court was simply confused. And that was one of their grounds for overturning a case that had been law for a couple, 3 decades, because they were confused. Where it really gets dicey, towards the end, Williamson County was just not wrong. Its reasoning was exceptionally ill-founded and conflicted with much of our takings jurisprudence. Now, this is the majority decision, the 5 justices that ruled in favor of basically doing away with that state compensation prong. Justice Kagan wrote the dissent, and it's a wonderful dissent. She focuses in on how can there be a taking if there is a remedy to get just compensation. But the majority is saying that the act itself, if it's somebody that's allowed to walk on your property, or if the regulation takes away too many of your property rights, that at that point, there's a constitutional violation. And the majority ignored that second prong about whether or not you can get just compensation in the state court system. And Justice Kagan really focused in on that. She said the right that clause confers is not to be free from governmental takings of property for public purposes. Instead, the right is to be free from those takings when the government fails to provide just compensation. In other words, the government can take private property for public purposes so long as it fairly pays the property owner. So there's 4 justices that believe the act that might rise to a taking, that doesn't trigger the constitutional violation until there's been a denial through the state court system of a potential for compensation. If compensation is denied, then you're allowed to go to the federal court. The other in the weeds on this is under the federal full faith and credit. What the majority was pointing to is that many times if a property owner went to state court first and lost, that the full faith and credit doctrine, when the property owner went to federal court, the state court findings were preclusive on the property owner in federal court. So many times, even though they had the right to go to federal court, the findings of the state court were binding on the federal court, and they would lose and never have their day in federal court on a Fifth Amendment takings claim. And the majority focused highly on that. One of the other things that Justice Kagan focused in on is the takings clause is different because it does not prohibit takings. To the contrary, it permits them, provided the government provides just compensation. So when the government takes and pays, it is not violating the Constitution at all. How many of you have been in a state court trial? All right, just a few. How many of you have been in a federal court trial? They find you not guilty, David. What's going to happen as a result of this decision, allowing property owners to go straight to federal court, is y'all are going to end up in federal court much more than state court, because you're no longer going to have the property owner go to state court first. And if the analysis is correct that the constitutional violation occurred as a result of the governmental act, not because there wasn't just compensation, your liability as a government employee, I think, is potentially going to be exposed as a defendant in the lawsuit in a federal constitutional claim, because the violation occurred according to the majority once you applied that regulation, or once you sent the code enforcement guy to trespass on the property, and you're looking at a whole new level of exposure from a public employee perspective. And then the last part on that I want to reference is there's a doctrine called stare decisis, and that doctrine pertains to when a new court should overrule a prior court's decision. And there are factors that go into it. They're laid out in this decision. And if you follow the news for the last year or so dealing with new folks going on the Supreme Court and the question of who's going to overturn what and what type of decisions might be overturned, well, stare decisis is kind of the test for whether a decision is overturned or not. And at the end of Justice Kagan's dissent, she says, just last month, when the court overturned another long-standing precedent, Justice Breyer penned a dissent. He wrote of the dangers of reversing legal course, quote, only because 5 members of a later court decide that an earlier ruling was incorrect. He concluded today's decision can only cause one to wonder, which cases will the court overrule next? Well, that didn't take long. Now one may wonder yet again. So there is a real tension at the Supreme Court that in prior years, you didn't see laid out quite as clearly in the dissent and in the majority decisions. But this is pretty good reading if you like reading this kind of stuff. So, like, for us legal wonks, it's good reading. Skip over here, skip over that one. All right, let me go to, let me look at the time too. I don't want to go long on you guys. All right, we got 11. This is just a quick case. Property owner sought a permit to demolish a cottage located in Coconut Grove. The zoning administrator approved the permit. The neighbors successfully appealed in a hearing before the Planning, Zoning, and Appeals Board. And the circuit court, sitting in appellate capacity, overturned or reversed the PCAB's decision. When you read this decision, the circuit court actually got in the weeds on the code, and the PCAB relied upon language in the intent section of the code. And what the court held was that the intent section of the code didn't provide criteria to evaluate the application for the permit, and that it was inappropriate to rely upon the intent provisions, and that essentially by doing so, it was arbitrary and capricious. So we included this one just to, when you're looking at your code, this is an example of a court saying, construe your code based upon not the intent section, but the section that sets forth the criteria for your decision. And failure to do so could result in a decision that you were arbitrary and capricious. Oops. City of Venice, this is a fun case. It's another one where if you just want to read about takings and exactions on a Sunday morning. The City of Venice filed a declaratory judgment lawsuit to determine the validity of various land dedication exactions contained in the pre-annexation agreement. And they entered into, I think it was 7 or 8 pre-annexation agreements with former owners. And they annexed the property. It was through a voluntary annexation. And in the pre-annexation agreements, there were monetary exactions and there were land exactions. And the owners that entered into the agreements voluntarily accepted those exactions. Well, go forward with new owners, and there was a dispute regarding whether those monetary exactions and the land exactions were valid. The city filed a declaratory judgment asking the circuit court to declare whether the money exactions and the land exactions were valid. And it's a bad decision for the city. When you read the decision, the city had conceded that the money exactions were not based upon any study, analysis, or factual basis. When you see that in a word, you pretty much know where we're going next. The Supreme Court applied the U.S. Supreme Court's analysis in Nolan, Dolan, and Coons. And if those of you that recall, probably about 7 years ago, we were talking about Nolan and Dolan, and I was the one that said they would not accept jurisdiction of Coons because it did not rhyme with Nolan and Dolan. I was wrong. And the land exactions were to widen a roadway, and similarly, the city had no study that established that the development that was proposed in the pre-annexation agreements after the property was annexed would create a need for the road to be widened. And so the court did a nice analysis of Nolan, Dolan, and Coons and concluded that the money exactions and the land exactions were unconstitutional, and it validated them. And the quote is towards the end of the decision, it's kind of nice. The exactions in this case are nothing more than a modern-day, sophisticated, unconstitutional taking. Our forebears fought a war of independence to ensure our citizens would have these rights.
They were thinking about
You
impact.
think he was a little irritated? This is my last one, then we'll open up for some questions. It's really, no, actually, I got one more after this. Shamrock versus Remark. Remark was a planning commissioner. And the reason I included it, really the facts had nothing to do with planning and land use, even though the dispute arose out of rezoning and developing property. The city planning department denied the rezoning request. The planning board upheld the decision. Remark was a member of the planning board. Before she was on the planning board, she wrote a letter opposing it. She actually opposed it while on the planning board. The project was denied, and the only reason we're here is, of course, they sued. Remark was not named as a defendant, and she was deposed. Prior to being deposed, They had tried 6 times to actually get the deposition. They just did a regular notice of taking deposition. And then finally, the developer filed what's called a deposition, or notice of taking deposition ducis tecum. And that requires the person being deposed to bring certain documents. So she showed up at her deposition and informed the developer that she had destroyed her computer. She had gotten a new laptop before she got the notice ducis tecum, and she had destroyed everything on the old computer. She did not preserve any records, she did not preserve any documents, she did not preserve any emails, and did not tell the city attorney. Because the court determined that she received the ducis tecum notice after she had destroyed her laptop or her computer, the court held that she was under no obligation to preserve evidence and did not have a legal duty to Shamrock to have done so. Now, if she had gotten the ducis tecum notice first, the decision would have been a little bit different. What I found really remarkable is I looked at this decision three times, including this morning in case I missed it, but she just destroyed emails, documents regarding the Planning Commission, and there was no discussion of the Public Records Act. That's probably the next lawsuit we'll see as a result. But at this point, we'll open it up for questions. Sir?
I'm curious as to what you and the panelists think about the position of the common law writ of certiorari, maybe growing in significance in light of the diminishment of the consistency challenge. And what my really specific question is the definition of consistency is very broad and includes violations of law, not just inconsistency with the comp plan, but inconsistency with other land development regulations. But then the consistency challenge is a little bit more narrow, and then we see under Hine that maybe the consistency challenge is even more narrow than we thought before. How big is the scope of the common law writ of cert? When can we bring that challenge as folks who are concerned about local government action on development?
I'll take a hit unless you want to go first, Nancy.
I read the common law cert to be very limited. It's only applicable for a violation of a land development code or a procedural due process issue or departure from the essential requirements of law. It cannot be used to get to violations of a comprehensive plan. And the most difficult part of a certiorari proceeding is it's based upon the record that was created below. Where under 3215, if you had a neighbor call you and say, hey, they're building a big box next to my single family home, I'm going to have all kinds of light. The fact that you didn't have a record didn't preclude you from bringing a 3215. It was de novo. So you got to call all new witnesses before a circuit court judge. But cert's just the opposite. You get one bite to create a record before the local government, and the judge looks at what I call the black box that goes up. The exhibits, the transcript, doesn't get to have any new testimony. So if the neighbors didn't bring any expert witnesses, didn't bring a court reporter, which also makes it interesting, you have a failure to create a legitimate record. And then the final straw is it's not a way 5149. A circuit court judge is bound to approve a local government's decision if there's any competent substantial evidence in the record to approve. So even if they had a planner that said this is the worst thing ever, if the developer had a planner that said this is the best thing ever, the fact that they had a best thing ever in the record, the judge doesn't look at the opponent's expert. They just say, is there any evidence in this record to support what the local government did? So I think it's really weakening the ability to challenge development if we're limited to cert.
And I would add that I think we would need to see whether the court would apply strict scrutiny in a certiorari case, and whether Snyder, would apply that way. I think it would, but as David mentions, on certiorari, there's a slightly different standard normally. And the other thing that I would add is that local government procedures are typically not adequate for challengers to make a record. There are time limits. Some local governments don't allow cross-examination. It's nothing like a trial, as we all know. That means the burden would be on challengers to just give reams of paper, to the local government, which the local government, no doubt, would not read. Do they read our staff reports? Would they be reading, expert testimony? So I think that even though there is that provision in 3215 that if you adopt these quasi-judicial procedures, then you can have a different route, over the many years, there have been very few local governments, if any, that have adopted those procedures that give the adequacy of due process that you would otherwise have in a de novo proceeding. So I don't think it's a very real way to expect consistency to be upheld.
Anybody, sir?
David, does the next decision mean that we have the potential for federal courts hearing land use cases? And I know in Southwest Florida, we have one federal judge. How are they equipped for that sort of thing?
And that's one of the things that Justice Kagan pointed out, is that this is going to bring a multiple layer of land use cases that involve state court issues, state law issues to federal court. And typically federal courts are the last resort for state land use disputes, and now they'll be the first resort.
Can we take that one step further? I'm assuming from what you said, based on the answer to that question, that in most cases, federal court would be the preferred vehicle for a developer that felt like he had a case in this case. And if the answer is no, can you elaborate why that might be?
Nancy? Shannon?
I'll just quickly say, I do think that plaintiffs will want to go to federal court for a number of reasons. One is we normally expect that federal court has a better understanding of
This is being taped.
the law, only because federal courts have clerks and resources that state courts often don't provide. But the second issue is that, as we know, the Senate, the U.S. Senate, has been very busy populating federal courts with property rights activists. And that's basically all they do these days in the Senate. So the whole, I wouldn't call it bias, but the whole focus of a lot of the new federal courts will not be very friendly, I think, to land use regulation.
Well, I think one irony with this is that for a developer, federal court may be now the better venue. But it's interesting to me that on permitting issues, federal permitting issues, like wetlands permitting issues, for example, that, there are those that are all about, the state being delegated the responsibility and pursuing, challenges in state court. Or administrative proceedings. So it's interesting to me, just sort of the dichotomy between the two.
Sure.
You talked about challenges to the prevailing party, House 7103. Has there been any challenges to the affordable housing or the inclusionary housing laws?
Not that I know of. I mean, there might be some legislators that file legislation to address that, but not that I know of. I haven't heard any interest in that.
Anybody else? Sir?
You kind of went over the new comp plan for a new municipality that changes in section 103. Do you read that section to only apply to new local governments, or where it says a comp plan adopted after January 1st, is that applicable to any new comp plan?
Yeah, I mean, I read it as applying only to new government, but I believe, if I'm recalling correctly, there was some language floating around on other bills that didn't make it, where there was an attempt, to apply that more broadly. So, I mean, that would be one thing I would worry about, is people think, oh, that's a good idea for comp plans in general. And then And then to me, it's like, well, we've gotten rid of the DRI process, you know? I mean, it would seem that a benefit of that is that you don't have, you know, this sort of long-term vesting, where it might, you know, the business models change, local governments change, it may no longer be appropriate. So, you know, I think that's, to me, that's a real concern, is for that to be applied more globally.
But you would think now that that's the way that it's written, it only applies to new.
Yeah.
I'm glad from fear. It's been my experience that most, whether they're federal or state court judges, have very little land use understanding. They've come from being a prosecutor or a family law attorney. I know very few land use attorneys who became judges. And much of what we talk about is Greek. And I can see somebody making the argument that a local government did a wholesale adoption of their comprehensive plan. This is our new comprehensive plan, not just an amendment to the flu or to the flu. And then somebody would try to take that language and run with it and say, well, Your Honor, it says new comp plan, and this is a new comp plan. And so I don't have certainty that it's going to be as limited as I would hope it would be. It's in a section that if you read it, it should be limited to new municipalities. But we've seen crazy things for 30 years.
David, if I could just say that Janet does a lot of lobbying for nonprofits in the state legislature, and she knows a little bit about how those changes happened this year. And I just invite her to sort of explain how 7103 actually got adopted.
Well, I mean, the particular 3215 changes just, you know, popped from the ether onto the bill. I guess on the House bill, had never been heard in committee, et cetera. Thomas, I know you were watching it. Do you have anything to add?
The amendments came at the last minute from a floor amendment by Senator Brandeis out of Pinellas County in the last 3 days of session, 4 days of session.
Yeah. And, you know, rumor has it that the 3215 provision and also the new comp plan, you know, vesting provision, that those were associated with specific individual developments. And I find it so annoying as an attorney, that offensive, you know, that you can toil away for years, you know, under following the rules, following the remedies that are available to you. And then, you know, in a blink of a last minute floor amendment, you know, there goes your 10 years of work. You know, it's just, to me, it's, you know, it's so unfair to, you know, citizens, developer, whomever, you know, are engaging in litigation based on, you know, an established set of rules. To the fact where it's not uncommon now for legislators to retroactively apply some of these changes. So that's my commentary on
I
that.
completely can't agree, Janet. In fact, tomorrow morning will be a customary use panel, so if you want to talk about being irritated at the legislature, I have a few things to add tomorrow to that. Anybody else?
Quick question,
Sure.
does that prevailing party receives compensation law apply to federal cases?
No.
No.
State. It's a state cause of action that will be bringing to state court. So, wrap it up. I'm told to wrap it up. Last question.
One question on the timeframes. Is there a definition on deemed complete as opposed to the final approval? I'm talking about the 30 days deemed complete and then the 121 80 days.
There are no definitions. Thank you, folks.